As soon as you're ready. So.
Okay, I think we have welcome. Good morning, Delegate Walker.
Good morning.
All right, good morning. We are good. Let's get it started.
Delegate Guzman, would you like me to start with the attendance?
Oh, yes. So this meeting will come to order. Start by recording attendance. Please, clerk, open the roll.
Delegate Avoli.
Present.
Delegate Avoli is present. Madam Chair, we have a quorum.
Thank you, Madam Clerk. And I understand that Delegate Delaney is in a conflict on a crime subcommittee for courts of justice, so she'll be on and off and available if necessary. And I want to welcome everyone. Good morning to our first meeting of the Subcommittee of Social Services. And I want to thank each one of you for joining us this morning. So this meeting will come to order as we have quorum. And why don't we get started, Madam Clerk?
Madam Chair, our first bill on the agenda is House Bill 1820 by Delegate Helmer.
If Delegate Helmer is on the public, please let him in.
Okay.
Good morning, Delegate Helmer. Can he hear us?
He looks.
Delegate Helmer, good morning. Can you hear us?
It looks like he can't hear us.
You're good? Okay. So Delegate Helmer, we understand you have House Bill 1820. The floor is yours.
Madam Chair, are you able to hear me?
Yes, we can now.
All right, thank you. Madam Chair, members of the subcommittee, good morning. Thank you all for your consideration of this legislation before you, House Bill 1820. Madam Chair, there is a substitute.
Okay, so we have a substitute. Would you like to explain the substitute? Would you like the clerk to go over the substitute?
I'd be happy to speak to the substitute in lieu of speaking to the underlying bill that it replaces at the same time, if that would be your pleasure, Madam Chair.
Okay, could the clerk tell us if that substitute is available in IHAT?
Yes, it just released the substitute. There's a short lag, but it should be available very soon. You may have to go to the public version of LIS to view it that way. I'm not sure. Sometimes there's a hang up.
Okay. Well, Madam Chair, as it's posting, if it would be your pleasure, I'll go ahead and explain the substitute and answer any questions. So, Madam Chair,
yes,
members of the subcommittee, we're one of 7 out of 50 states that has not implemented broad-based categorical eligibility. We're missing out on helping more than 25,000 Virginian families to allow them to feed themselves, and also missing out on millions of federal dollars for our Commonwealth.
Hold on substitute in front Helmer is the substitute. Okay, yeah, that's fine. Okay,
the substitute in front of you increases Virginians' access to SNAP and other benefits by implementing broad-based categorical eligibility, setting it at 200% of the federal poverty level, and removing the asset test. It also makes benefit programs more readily available to those pursuing post-secondary educational opportunities, incentivizing education to get higher paying jobs and keep people off of public benefits, rather than incentivizing them to do lower paying jobs now that would require them again and again to require public benefits. It also makes benefit programs more readily available. Furthermore, every SNAP dollar generates about $1.50 in economic activity for our Commonwealth. So therefore, our state's small investment in broad-based categorical eligibility results in at least an estimated $10.5 million of additional economic activity supporting our small businesses and creating jobs. Compared to the original bill, the substitute just does a small number of things. It explicitly states that post-secondary educational activities are allowable under the VIEW program. So it's just a movement of where we placed it in the code. It allows SNAP employment and training requirements to be satisfied through post-secondary education. It adds language that the bill applies within the federal provisions of the program. And then it replaces references to the food stamp program with the federal term that is used, the Supplemental Nutrition Assistance Program, SNAP. This bill helps tens of thousands of Virginians put food on the table. It also brings in millions of dollars of economic activity. If states like Montana and North Dakota can have a gross income eligibility level of 200% of the federal poverty level and no acid tests, we can as well. With 1820, we have the rare opportunity to pass a bill that has no downsides and no trade-offs in support of Virginia's people and to grow our economy at virtually no cost to the state. I hope it's the will of the subcommittee to report this bill and look forward to your questions.
Okay, Delegate Hunter, we're going to have to move the substitute first. So if I could have a motion.
Moved. Second.
Okay. It has been moved by Delegate Ayers and seconded by Delegate Tran. And I believe that, is there anything additional now that the substitute is before us, Delegate Helmer, that you would like to add?
No, Madam Chair. This bill, just to one piece of explanation, the substitute was drafted with by DSS, which we really appreciate that. And I know Commissioner Storin, I believe he's available in the meeting room as well if there are questions for DSS as well. But I really appreciate. Just wanted to express my thanks for VPLC and American Heart Association and the Hope Center and DSS for helping us work through all of this, work through the bill and to draft the substitute.
Okay, thank you, Delegate Helmer. We're going to hear to the public before we move into questions. Is that okay with everybody? So, Madam Clerk, can we please bring people in favor of the bill?
Yes, Madam Chair. Our first speaker we have is Salam Badi with the Virginia Poverty Law Center.
Hi, good morning. Can you hear me?
Yes, good morning.
Hi, good morning, Madam Chair. My name is Salam Bhatti, and I am the Virginia Poverty Law Center's public benefits attorney. 60 years ago, on this very day, JFK began his inaugural address by saying that man holds in his mortal hands the power to abolish all forms of human poverty and all forms of human life. And looking back, how have we done? Well, we needn't look any further than what artist Tupac Shakur said in the early 90s, when he said that they got money for wars, but can't feed the poor. Now with HB 1820, we have the opportunity to change this and make things right. As Delegate Helmer said, this will help support over 25,000 low-income working families, promote asset building to get people out of poverty, and to improve state administration while lowering state administration expenses. The bill's provisions regarding TANF and SNAP for college students will go a long way towards strengthening Virginia's future. We thank Delegate Helmer for bringing this bill, and we thank the governor for putting CAT-L into his budget. Please vote yes on HB 1820.
Thank you.
Madam Chair, our next speaker is Kenneth Gilliam with the New Virginia Majority.
It is still morning, so good morning, Madam Chair, members of the subcommittee. Thank you all so much for your time today. We strongly support this bill and also using the state's flexibility to think through how we can make changes to our categories. In addition to that, also being a former higher education and student affairs professional at Old Dominion University, I can tell you very clearly that as our students enter our 2-year and 4-year institutions, they have many barriers to their academic success, particularly if they're low-income students, first-generation college students, or come from traditional, non-traditional backgrounds. And so thinking through that students who are TANF eligible and currently have TANF, being able to remove that work requirement provision or lessen it will play a key role in their success at their respective institutions. So for those reasons, we strongly support the bill and thank Delegate Helmer and others for carrying this piece of legislation.
Thank you.
Madam Chair, our next witness is Chelsea Bennett with the American Heart Association.
Good morning, committee. Again, Chelsea Bennett with the American Heart Association. I have the honor of serving as the Virginia Government Relations Director. And we've heard some lyrics from Tupac. We've heard from an higher educational professional. And so I'll just say on behalf of AHA, our focus continues to be about heart health and brain health. And as we think about the benefits of SNAP and being able to expand that through BBCE, we are fully supportive of this. As you also heard, one of the things that's important to us here at the Heart Association is just the evidence that suggests that BBCE simplifies the application process for potential SNAP participants, as well as reduces administrative costs for state agencies. And so while we look at heart health, brain health, we also want to make sure that the participants, that their process is simplified, it's smooth, as well as we're looking at the cost for the state. And so for all those reasons, the American Heart Association supports HB 1820. Thank you.
Thank you.
Madam Chair, our next speaker is Carrie Welton with the Hope Center for College Community and Justice.
Okay.
Good morning. Thank you very much, Madam Chair, and to all the members of the committee for allowing me to speak on behalf of House Bill 1820 and the substitute. On behalf of the Hope Center for College Community and Justice, as well as in my personal capacity as a resident of Virginia, I urge you to pass the substitute. The passage of this bill will not only bring critical and timely federal resources to the Commonwealth that will reduce food insecurity, but it will support the state's future workforce by improving access to basic needs programs for college students. At present, Virginia ends eligibility for the Supplemental Nutrition Assistance Program at 130% of the federal poverty level. But what does that really mean? For a 3-person household, that means their annual income cannot exceed about $38,000 a year. The change in HB 1820 to increase eligibility up to 200% of the federal poverty level means this same family can access SNAP until their income reaches about $43,000 a year. As a household's income increases, this allows their SNAP benefit to slowly decrease, and this gradual phase out better supports wage growth and allows families a cushion as they transition off of public benefits. HB 1820 also recognizes the ongoing challenges that students face combining attendance with work and other responsibilities. This bill maximizes the federal rules in student eligibility and eases restrictions that force students to choose between continuing their education, delaying their education, or just trying to subsist on low-wage work. The Hope Center conducted a survey of students at the onset of the pandemic, completed by over 38,000 students, and found that 44% of students at 2-year institutions and 38% of students at 4-year institutions were experiencing food insecurity. They were also impacted by record job loss, unemployment, and show that 2/3 of students were experiencing job insecurity, with 1/3 having recently lost a job. We know this is also true for Virginia because the State Council of Higher Education reported that over the 2015-16 academic year, an estimated 77,000 Virginia undergraduate students were potentially eligible for SNAP, yet only about 11,000 received it all academic year. The passage of HB 1820 is an important contribution to fostering an educated workforce by improving access to critical basic needs supports for college students. Thank you to Delegate Helmer for bringing this bill forward and to the committee for allowing me to speak today on behalf of Virginians and in support of HB 1820.
Madam Chair, our final witness for House Bill 1820 is Julia Billingsley with Virginia 21.
Good morning, Madam Chair. Speaking specifically to the post-secondary aspect of this legislation, we strongly support removing barriers for students to access TANF and food stamps. Recent studies have shown that as many as 1 in 10 Virginian students struggle daily with food insecurity, and many others struggle with other financial barriers to completing a post-secondary degree. We thank the patron for highlighting this issue, and thank you.
Thank you. So we don't have any more speakers?
That was the final speaker.
Okay, thank you, Madam Clerk. Do we have any questions to the patron from members of the committee? Delegate Air?
Madam Chair, I don't have a question, but I do just want to make a comment. I want to echo the support that has been offered by the advocates today and thank Delegate Helmer and place emphasis on the fact that we're talking about 25,000 of some of the most vulnerable Virginians. And as we think about what the future opportunity needs to be for folks coming out of this pandemic, particularly college age Virginians, this will be a tremendous tool to help give them the very best and strongest opportunity. So I just think that it's important that as we are thinking through relief, as we're thinking through policies that have been punitive and long overdue, quite frankly, here in the Commonwealth, we can add this policy to that list. And anytime you can marry JFK and Tupac Shakur together on a policy, it's a win in my book. So I would like to make a motion at the appropriate time.
Thank you, Delegate Eric. Do we have any more questions from members of the committee? Okay, being none, Delegate Eric.
Delegate Guzman, is it fair and accurate to state that this needs to be a report and refer, or is it merely a report?
It's a report and refer, Delegate Eric.
Great, I thought so. So I would like to move that House Bill 1820 be reported and referred to the Appropriations Committee.
I would like to second that, Delegate Guzman.
Okay, thank you. The bill has been properly motioned to be reported and referred to Appropriations by Delegate Eric and seconded by Delegate Tran. And we want to welcome the chair that is joining us this morning. Welcome, Mr. Chairman. So, Madam Clerk, please open the rolls. Close the rolls. So the bill, Delegate Helmer reports its report and referred to Appropriations in a vote 5-0, 6-0, I believe. Sorry, went away. Thank you.
Thank you, Madam Chair. Thank you, members of the committee. Have a great inauguration day.
Thank you. All right. Next on the agenda, Madam Clerk. You are muted.
Our next bill on the agenda, Madam Chair, is House Bill 1957, carried by Delegate Avoli.
Okay, Delegate Avoli, you are not new to this committee, so go right ahead. The floor is yours.
Madam Chair and Mr. Chair, thank you. And I will answer the questions as Mr. Chair always asks, what the bill is and why it should pass. So, HB 1957 reduces the burden on families and local departments of social services by eliminating the requirement for the investigation report in certain adult adoptions. I have a couple of folks who will give witness in a waiting room to speak to specific examples when the investigation requirement can become very burdensome. But simply, as long as a judge is satisfied on the basis of good cause shown by both the adopter and the adoptee parties, it is unnecessary to require the local DSS to investigate further at a cost to the adopted party. That is the bill itself. I shall be glad to answer any questions and at time appropriate to have our expert witnesses speak. Thank you, Madam Chair.
Thank you, Delegate Avoli. Madam Clerk, do we have individuals in support or against this bill? Please bring them in.
Yes, Madam Chair. We have two speakers for House Bill 1957. The first witness is Jackie Blundell.
Good morning.
Good morning.
There are 1,000 emotional reasons for HB 1957. One for each tear. My daughter cried every time her adult adoption was delayed by the home study ordered by a well-meaning judge. But that's a family member matter, and we can cope with that. But there are at least two practical reasons that HB 1957 is important. First, to make the best use of Virginia's resources, and secondly, to make the adult adoption system more equitable. To start with the finances, the investigation and report process was not designed for, nor is it meaningful for adult adoptions. Using up the resources for organizations that were intended to protect children, for them to make CPS professionals do things that they're neither prepared for nor trained in make no sense. It made no sense for CPS who spent resources finding out what kind of blood pressure medicine I took so that I could adopt a 23-year-old woman. It made no sense for CPS professionals to inspect my house when the daughter I was adopting lived 3 hours away in her own house. The list goes on and on. I'll spare you the gory details unless you want the rest of them. The other part of it is that the home order, the home study, the report and investigation has a profoundly disparate impact on those that do not have my family's income, education, or tradition of being unwilling to be dictated to by bureaucrats. What my daughter, of course, calls privilege. Had my husband been a school teacher and I an LPN, we couldn't have afforded the legal fees, the home study fees, the insurance, care pays. We had to have physicals to do this, and the time off for meetings and inspections. We had the financial means to overcome the multiple roadblocks we hit. Had our financial situation been more typical, we likely would have been forced to give up. I don't know what would have become of my daughter, Nicole. What bothers me even more is the intimidation factor involved. Unintentional, but no doubt there. So I've been a single mom trying to hold body and soul together on a minimum wage and English not being a second language to me. How do you think I would have reacted when the professionals said to me, "You will release your therapy records to me," or "If you don't give me the contact information for X person, this application will stop now"? Both of those things were said to us. Having my privilege, as my daughter calls it, I snorted and called the attorney. We did neither of those things. But had I been that single mom, I likely wouldn't have had the attorney or the money or the confidence to do so. That's not fair. Between the opioid epidemic, COVID, the ensuing economic disruptions, the divisions that are occurring in our country right now, our families are going to have to reconfigure. They are reconfiguring. And Virginia should be doing everything in its power to make sure that it equitably assists as many families as possible to preserve, defend, and establish the bonds that hold our lives together. HB 1957 is a tiny step, but an important one. Thank you.
Thank you. We have the Yes.
Is there another witness? I have a question for council at the appropriate time.
All right. Thank you, Mr. Chairman.
Madam Chair, I do have one more witness to speak to this bill.
All right. Go right ahead, Madam Clerk.
Our next witness is Stanton Phillips with Newfound Families.
Good morning. My name is Stanton Phillips. I am president of Newfound Families, Virginia's statewide adoption, foster care, and kinship care support group of about 1,000 members. I am an attorney who practices adoption law. I've been doing adoptions for 39 years and close to 4,000 adoptions. I've also written extensively, including family law and practice, where in mid-90s, I wrote the chapter in Family Law and Practice, the nationwide treatise on adoption law, where I had a chance to review all 50 states' adult adoption statutes for that publication in my drafting. I was asked by Virginia Department of Social Services to review this bill and make comments for them to give my analysis, and that led me to here to testifying today. What this bill does is makes it optional for the judge to require the home study. Currently, the law mandates that a home study be conducted in every non-relative case where the child has not lived in the home for at least 3 months prior to the 18th birthday. I believe this originated maybe 50, 60, 70 years ago, this requirement, based on some old trust and estates case where there was some unscrupulous activity. In my practice, I have not seen a single situation, and I've handled hundreds of adult adoptions, where the investigation has really made any meaningful effort or impact on a case. When I looked at this legislation originally, I was not sure that it was necessary, but the more I analyzed it and thought about it, Virginia has the most complex adult adoption statute of any of the 50 states. All this does is give the judge the option of waiving the investigation. And frankly, what does an investigation consist of? Filling an application and going to the person's home. As the previous speaker mentioned, they ask questions that really don't even have that much to do with the adoption. I look at it as, what is the burden on the local Department of Social Services? And it seems to be an unnecessary task when you weigh it against what is accomplished. And it also becomes an additional expense for the adoptive family. Therefore, I am recommending in favor of the bill to allow the judge to waive the investigation. Thank you.
Madam Chair,
Thank you. Yes, Delegate Air.
may I ask a question of the gentleman?
Sure, go ahead.
Thank you so much. Sir, is it possible you can share with me, being less familiar with the statute, so if we move in this direction where it's the option of the judge, are there common elements and or triggers that would then subject the judge to possibly order the home study based on your experience? Is it ultimately the judge's total discretion? I just want a better understanding.
Correct. The current statute mandates investigations for non-relatives when the child has not been in the home for at least 3 months before the 18th birthday. This will give the judge the option of waiving that investigation. Does that answer your question?
Yeah, I'm sorry. Let me restate it. I guess I understand that. I'm saying, in your experience, if the judge then has this discretion to waive the investigation, will it then be, I guess, through the process, does an individual have to prove then that the investigation isn't necessary? Or is it the reverse, where there has to be some mitigating circumstance for him to order the investigation? I'm trying to understand from a process standpoint how it would then work when before the judge.
When the statutory scheme was last revised in 2006, the statute has always left it open for the judge to have the investigation, but the statute basically discourages the judge. So the judge will read through the petition for the adoption. If the judge has questions, he may order the investigation. It's always in the discretion of the judge, though the statute discourages the judge from ordering investigations generally in adult adoptions, with the exception of the current statute.
Madam Chair.
Yes, Delegate Air.
Just yes.
Okay. Yes, Mr. Chairman.
No, I was trying to tell you that Delegate Air wanted to ask a follow-up question.
Yeah, Delegate. No, I don't think she.
Yeah.
You're good? Yep. Okay.
Oh, she did. Okay. No,
Yes.
I apologize. I thought she was asking a follow-up question. Is there, okay, is there anybody else ahead of me?
Nope. Not that I'm aware.
Okay, just wanted. Okay, so really, this is just a relatively small change, only for people that are being adopted over the age of 18. Is that correct? And the gentleman said that he had been contacted by DSS for his opinions. Did DSS take a position on the bill? I forgot your name. I'm sorry. The practitioner.
Stan Phillips.
Phillips.
DSS does not take a position on these bills. They ask for input and then discuss it amongst themselves. But they do not come out with an official opinion.
Well, I don't want to surprise you, but they do sometimes come out with official positions. I don't know if adoption, they decide not to do anything on adoptions, but they do take positions on occasion. Matter of fact, the last bill we just took up was an administration bill from DSS. The family law branch of the Virginia Bar, have they looked at this? Do they have any concerns about this? I'm sure you're a member of the family law section with 4,000 adoptions behind you.
To my knowledge, they have not.
Have they
looked
taken this up?
No.
Okay. Okay. All right. Well, I guess that answers my question. A lot of times, and from memory, complicated adoption bills do get sorted out in the courts committee because this is a legal transaction that's taken place. But it seems like this is relatively simple. Looks like it's relatively simple, and I would have no problem moving. If there's something that concerns people about this bill, we'll find out about it during the process if we move it out of committee today.
Thank you, Delegate.
That's all. Thanks.
Thank you, Mr. Chairman. Delegate Tran, you have a question.
Thank you so much, Madam Chair. I think I really appreciated the previous witness, Ms. Jackie, for sharing her story of adopting her daughter, who was an adult at that time. And I believe that her situation that she described was one where the adult adoptee was not living in her home. And so some of the inquiries and part of the investigation may not have been applicable. But I just want to make sure I understand, in a situation where it is an adoption of a person who's 18 years and older, but if that person was living in the home with the new adopted parents, and it could be a situation where lots of different situations might come to mind for that, right? Somebody has a disability who has to live in that home. Somebody might not have might have an illness where they are not incapable of making those decisions themselves. I just want to make sure, based on this bill, maybe this is a question for council, that the circuit court can still conduct that investigation if it deems that those situations necessitate such an investigation, right? So it's a different type of situation than the one that was presented.
The bill does.
The bill, if you look at the beginning of the bill, lines 13 through 14, that first sentence there makes clear that adoptions under this article, which are the adult adoptions that we're talking about, an investigation or report shall not be made unless the circuit court, in its discretion, so requires. So discretion remains with the court to decide whether or not that investigation is appropriate.
Madam Chair.
Yes, Delegate Air.
I want to just ask one final clarifying question. So without this legislation, a judge could not decide that a home study investigation is not necessary. I just want to make sure I'm understanding that without this legislation, the judge does not have that authority already.
Correct. It is mandated that the investigation occur under the current statute. This allows the judge to waive that investigation at the judge's discretion.
Thank you.
Okay. Do we have any additional questions? Is DSS on the queue? Is there anyone from staff here, Madam Clerk?
No, Madam Chair, we don't have anyone for this from DSS signed up to speak on this bill.
All right, so we work in motions.
I move to report.
Okay.
All right, the bill is properly reported and seconded. Please, clerk, open the rolls. All right, Delegate Avalo, your bill report 6-0. Congratulations.
Thank you, Madam Chair, and thank you, committee members and witnesses.
Thank you. All right, following bill.
Madam Chair, our next bill is House Bill 2065, patroned by Delegate McQuinn.
All right, Delegate McQueen, are you with us?
Delegate McQuinn, please unmute your microphone.
Good morning.
Good morning, Delegate McQueen.
Good morning. So you all are ready for me already, huh?
Yes, we are. The floor is yours.
All right. Let me move away. I am chairing another meeting, and so let me try to. All right. Let's see here. Okay. All right. Give me a chair. Good morning, and thank you, Madam Chair, for this opportunity to present my bill, House Bill 2065, the produce program bill. And at this time, I will present this and hope that you all will be so impressed by it. There will be no questions, and we go right on to having this bill put forward. Before I begin this, I guess, small amendment, I would like to include the Medical Society to the work group represented, listed in the bottom of the bill. Can the clerk, I'd like to do that, have this, I'm sorry, amendment, and can the clerk report the amendment, please?
Sure.
Yes. Madam Chair, the amendment will be made on line 40 of the bill in the attachment after pediatrics, comma, insert the Medical Society of Virginia, and I just released that online as well.
All right, thank you. Do we have anyone to adopt the amendment? Can we have a motion?
So moved.
Yeah.
All right, so the amendment, Delegate McQueen, has been moved by Delegate Tran and seconded by Delegate Air. So now the amended bill is before us. The floor is yours.
Thank you, Madam Chair. Many of you know that I have been working on this issue of food desert and food insecurities for many years. I guess around this time, when we look at it last year, the issue became, I guess it was magnified by circumstances of the time and COVID-19, which all of us are talking about. But last year, the number of Virginians who experienced food insecurity was approximately 850,000 people, Virginians, including 250,000 children. Then with the onset of the COVID-19 pandemic, estimated 445,000 additional Virginians have begun to experience food insecurity. That is more than 1 million Virginians in a Commonwealth where our population is about 8 million. It's around 8 million people. More than 1 million of them are finding themselves experiencing hunger. To me, that number is and continue to be unacceptable. And so I'm hoping that today we are here today to help in this whole produce program to help reduce that figure. I mean, we have the power to help change it, and we can start really by this bill. So this bill would direct the Department of Social Services to create a pilot produce prescription program. In this program, eligible individuals will have access to qualifying fruits and vegetables. This legislation also creates a work group to assist with defining a pilot model, such as identifying partners, establishing the length of the model, and determining the monthly voucher amount. It is a goal to work with health providers such as physicians, nurses, pediatricians, and dietitians to determine how best we can enable this program. And we also have an opportunity because of what is being done across the country. We have an opportunity to set a model, put this model in place that really would be the first of its country and in the country, and that is going through legislation to help provide it. So I'm hoping again that we can look at it, that it would be acceptable program that each of us will see is necessary in the state of Virginia and how we can move forward. We have a number of stakeholders ready to testify on behalf of the bill, including Chelsea Bennett from the American Heart Association, Dr. Katie Myers from the Virginia Department of Academy of Pediatrics, Andrew Lamar from VNA, Sarah Collins, Laura Brown, and a number of other voices who have been at the table helping to craft this and looking at how we can move, again, the produce prescription bill forward. So, Madam Chair, at this time, that is my presentation. And if there are other individuals who, I hope that you will open it for other individuals to speak, as well as at the appropriate time, ask any questions. Thank you.
Thank you, Delegate McQueen. Do we have any, can we go ahead and listen to the organizations that are going to speak in favor or against this bill, Madam Clerk, please?
Yes, Madam Chair. And before I go down the list, I just wanted to say that there are a number of people signed up to speak for this bill. Did you want me to set time limits for each witness to give their testimony?
Yes. How many do we have?
10.
10. Oops. So let's give them a minute and a half. Is that fair, everybody? Okay, a minute and a half. Thank you.
Okay. Our first witness to give testimony is Chelsea Bennett with the American Heart Association.
Okay, welcome.
Good morning.
We have a minute and a half so we can listen to everybody. Is that okay with you?
Yes, ma'am. I will keep it short. Again, good morning, committee. I am here to share support for HB 2065. As you heard, there are 10 other individuals here, yet this initiative is being supported by 15 other organizations. And so we are thrilled here at the American Heart Association. As you all have heard, the food insecurity rate here in Virginia has risen since COVID-19 started almost a year ago. Yet I also want to draw your attention as we think about heart health and brain health, that there are numerous studies that have demonstrated the correlation between food insecurity and poor health outcomes. And here at the Heart Association, one of the things that we often talk about is hypertension, because it is a symptomless, silent killer that quietly damages blood vessels and leads to serious health problems. And so how can you help those with hypertension? One way is through this produce prescription program, because a heart-healthy diet is key to helping reduce hypertension and hopefully eliminate it. And so we are hopeful that with your support in this committee, as well as the pilot funding of $2 million, that we will be able to help Medicaid and CHIP patients throughout the Commonwealth who also have diagnosed treatable conditions such as diabetes, hypertension, help them along this journey so that they can live a long and prosperous life. And I also would like to remind many of us, as we think about the Produce RX prescription program, that this is a preventative measure. So it's something that allows us to make an investment into our economy, into our Virginians alongside of us, that will help us in the long term with medical costs. Again, the Heart Association supports this, as well as we received support, a quote of support yesterday from the Speaker of the House, and I hope you all received that in your inbox last evening. Thank you again. Please support this measure.
Thank you. Next speaker.
Madam Chair, our next speaker is Kim Hutchinson with the Virginia Farmers Market Association.
Welcome. We have a minute and a half for you. Go ahead, Kim.
Thank you, Madam Chairman and subcommittee members, for allowing me to speak today. I'm the Executive Director of the Virginia Farmers Market Association, and we work with over 365 farmers markets, as well as over 20,000 farmers, producers, and food access vendors across the state of Virginia. Now more than ever during the difficult and unprecedented times of COVID-19, our association has focused on building safe community locations to address and support the food system needs of the Commonwealth by providing access to Virginia-grown and produced nutrient-dense food. And access to locally grown nutrient-dense food is important because poor diet is among the greatest health and societal challenges of our time, in causing death and disability, soaring healthcare spending, budget challenges for governments, et cetera. In Virginia, with the Medicaid expansion, we have 1.782 million people on Medicaid, which is 22% of our population. They are low-income individuals that are the predominant factors in poor diet, as we see in the healthcare system. In addition, nearly 1 in 5 in our
30 seconds
on healthcare. We avidly support the produce program. These programs provide healthier options for families who need it most, increase local sales and diversity of the customer base for participating businesses. And when linked to local agriculture, like at farmers markets, lead to more income for farmers. We thank you for our time today, and the Virginia Farmers Market Association supports House Bill 2065. Thank you, Madam Chairman and subcommittee members.
Thank you. Next speaker.
Madam Chair, our next speaker is Chloe Edwards with Voices for Virginia's Children.
Sure.
Good morning and thank you. My name is Chloe Edwards with Delegates. We're also home to the Racial Truth and Reconciliation Virginia campaign with over 400 coalition members and have the support of Virginia's 27 community networks. Layers of injustices contribute to inequitable food access, including America's legacy of redlining, housing discrimination, and disparities in access to wealth and opportunity. According to a 2016 national survey of children's health, families that reported adverse childhood experiences, such as domestic violence and substance use, were much more likely to experience food insecurity. While 19% of Virginia's children experienced 2 or more adverse childhood experiences, Black children experience it at almost double that rate at 37%. Not only does food and nutrition disparities contribute to poor health inequities, but childhood trauma also creates toxic stress. This creates compound health inequities. Please support this bill to ensure that children and youth have the ability to live long, healthy, successful lives, a basic human right. Thank you.
Thank you. Next speaker.
Madam Chair, our next speaker is Hugo Mogollon with Fresh Farm Markets.
Thank you so much. Good morning, subcommittee members. Thank you, Madam Chair, for this opportunity to testify and support House Bill 2065. My name is Hugo Mogollon. I'm the Executive Director of Fresh Farm, an organization that runs farmers markets in Northern Virginia. Fresh Farm represents thousands of Northern Virginia residents that visit our markets and spend their food benefits to advance of the programs that increase the intake of fruits and vegetables in their households. We hope to add produce directs to the list of benefits because it's a unique and innovative program that changes the quality of life of many families affected by diet-related illnesses. To understand the value of this program, it is essential to consider that poor diet-related illnesses such as diabetes, obesity, and high blood pressure are extremely costly for any community's economy and also families. Community members who participate in Produce RX programs have shown significant improvements on health outcomes such as BMI among 65% of participants. Also, 85% of people that participate in the program report improved in patients' relations with their healthcare. Produce RX need more than ever when the pandemic is increasing food insecurity across the state, disproportionately affecting the health of the most vulnerable population, residents such as seniors and low
30
income.
seconds.
Farmers markets play a vital role in tackling food insecurity in the state, and we urge you to pass this bill to increase access to fresh fruits and vegetables in Virginia residents. Thank you so much for the opportunity to talk.
Do we have next speaker?
Madam Chair, our next speaker is Sarah Collins with Virginia Academy of Nutrition and Dietetics.
Hi, my name is Sarah Collins. I'm a registered dietitian with the Virginia Academy of Nutrition and Dietetics. I have experience working as a clinical dietitian, and now I'm working towards a PhD in healthcare policy and research at VCU. The Virginia Academy of Nutrition and Dietetics would like to support this bill. It's well established that a diet rich in fruits and vegetables can protect against many chronic diseases, including heart disease, type 2 diabetes, and cancers. Despite this, most Virginians are not getting enough in their daily diet. According to the CDC, only 10.9% of all adults in Virginia meet their daily fruit intake recommendation. Even fewer people meet the vegetable recommendation at only 7.6%. The CDC recognizes that making fruits and vegetables both convenient and affordable can help communities increase their intake, which in turn is really beneficial for public health. Similar prescription programs have been studied in other states, and they show great promise to positively impact their communities. One example is a 2019 study from the University of Vermont, which showed that a similar fruit and vegetable program not only helped participants to buy more produce, but it resulted in a statistically significant shift towards healthier eating habits overall. It also showed that it helped participants
30 seconds.
more self-efficacy related to eating fruits and vegetables. This is just one example. I would love to provide more evidence from current literature if you're interested in learning more, but I think we can all agree that good nutrition is vital for the treatment and prevention of chronic disease. Please vote yes for House Bill 2065. It would help more people afford produce, something that's timely in light of the current pandemic and its associated financial hardships. Thank you.
Thank you.
Madam Chair, our next speaker is Yeli Montano.
Hi, good morning, Madam Chair and members of the subcommittee. My name is Yeli Montano, and I'm with GASA in Virginia. GASA and our 10,000 members support HB 2065 and thank Delegate McQuinn and the other supporting delegates for bringing this innovative public health initiative forward. Eating well and making proper food choices can be difficult to navigate for individuals of low income and those with underlying health conditions. Everyone should have access to necessary resources so they can access healthy diet choices to feed themselves and their families with wholesome, nutritious food. As of 2019, around 32% of adult Virginians had a body mass index or a BMI that would classify them as obese. And as you know, that poses great risk to their long-term health outcomes and their quality of life. This illustrates the need for this program, and this program is not something new. A similar but non-legislative initiative was launched in DC from 2012 to 2017, and it was found with great success. They saw an increase in well patient visits by 54%, and 50% of the program participants decreased their BMI. And the most recent similar program was launched this past October by the Center for Health Law and Policy Innovation of Harvard Law School, who started this initiative with the same goal. Again, nutritious foods and vegetables are not always financially feasible choices for families, and we asked the subcommittee to pass this bill so more Virginians can have a greater access to fruits and vegetables to help us prevent and address chronic illnesses. Thank you so much for your time and the opportunity to speak today.
Thank you.
Madam Chair, our next speaker is Valentina Vega with the Medical Society of Virginia.
Sure.
Members of the committee, Madam Chair, good morning. My name is Valentina
Morning.
Vega. I am here on behalf of the Medical Society of Virginia in support of House Bill 2065. When physicians diagnose patients, especially children in low-income settings with diabetes and high blood pressure, one of the biggest hurdles for following through with proper treatment is access to nutritious fruits and vegetables. So having this resource can really help physicians help their patients achieve optimal health. So we're here in favor of this bill, and I really thank you all for your time and consideration.
Thank you, Valentina. Very nice to see you. Next speaker.
Madam Chair, our next speaker is Laura Brown with Local Food Hub.
Sure.
Hi, I'm Laura Brown, Director of Community and Policy with Local Food Hub, a nonprofit organization that has a 6-year track record of operating produce prescription programs in Central Virginia. A statewide pilot program would expand the reach and impact of addressing food insecurity and poor health outcomes in Virginia. Local Food Hub has seen firsthand the benefits that fresh produce can bring to members of our community who face diet-related illness, nutrition insecurity, and hunger. We have found that providing access to fresh produce has numerous benefits to health clinic patients and their families, including decreases in blood pressure and A1C levels, healthy weight reduction, increased energy, better sleep, and the creation of healthy diets. Obesity in participants at one clinic dropped from 70% to 57% during one season, and other participants reported eating a cup of vegetables per day increased by 12% over the course of the program. One participant today just told me how valuable the program is to her budget and that she likes foods that she would otherwise never purchase because she does not have the budget to buy fresh produce, particularly if she didn't know if she would like it. These benefits go deeper in our community when the produce is sourced from local farms, keeping our dollars local and helping Virginia agriculture thrive. I support HB 2065, as does Local Food Hub.
Thank you.
Madam Chair, our next speaker is Katie Moyer with the American Academy of Pediatrics.
Good morning, Madam Chair and members of the subcommittee. My name is Katie Moyer, and I'm speaking on behalf of the Virginia chapter of the American Academy of Pediatrics in support of House Bill 2065. As a practicing pediatrician, I know firsthand the importance of ensuring children have access to healthy food. And unfortunately, I've also seen firsthand the prevalence of food insecurity amongst my own patients. Children from food insecure households are likely to be sick more often and recover from illness more slowly and even be hospitalized more frequently. Other speakers have addressed the importance of fruits and vegetables for health benefits. So I just wanted to also let you know that I have set up a food insecurity screening at my clinic, and that was established by a local pediatrician. So we work with a local food bank for Food for Others, and we've been able to give prescriptions to over and feed 1,000 individuals since we started the program in 2018. I think a produce prescription program would add additional resources to access for food as outlined in this bill and is urgently needed and will help healthcare providers like myself and other local pediatricians to get patients the healthy food that they need. Thank you very much for your time, and please support this important legislation.
Thank you.
Madam Chair, our final speaker for this bill is Andrew Lamar.
Thank you, Madam Chair. Andrew Lamar. Just wanted to add the support of the Virginia Nurses Association for this and thank the patron who has been an incredible champion on food access and food security issues for a long time now. This is a great innovative approach that'll help tie food access and security to health practitioners and their patients and really bringing those two perspectives together. So thanks again to the patron, and we support the bill. Thank you very much.
Thank you. Thank you. So members, do we have any questions to the patron? Okay, being none, is committee work in motions?
Move to report.
Second.
Oh, hold on one second. Yes, Sarah.
Madam Chair, should you report the bill? And it sounds like you're going to. This one is one that would need to appropriate.
We'll have to go to appropriations? Okay, we got the fiscal impact. Okay, I was surprised that I didn't see it last night. Okay, they just sneaked that through us. Yes,
Madam Chair, in reporting it has to be also reported with an amendment.
With an amendment, yes.
Yes.
All
Thank
right.
you.
Thank you,
Madam Chair, I move to report with an amendment and refer to appropriations.
Excuse me, has the amendment been passed?
Yes, we have at the beginning. Mm-hmm. All right. The motion to report and refer by Delegate Tran and has second. I can second the motion as the chair. So let's go ahead and open the roll.
Delegate Walker. Delegate Walker. Oh, I see. Madam Chair, all members have voted.
Thank you, Madam Clerk. Delegate McQueen, your bill report 6-0. Congratulations, and thank you for your.
Thank you, and thank you, Madam Chair and the committee. I do appreciate it. Thank you.
Thank you.
You have a good day.
Thank you. You too. Next bill on the agenda. This is.
Our next bill on the agenda is House Bill 2191, patroned by Delegate Lefwich.
All right, and this bill will need to be referred and reported to appropriations if the secretary so. So, Delegate Lefwich.
Thank you, Madam Chairman. There is an amendment, and I would ask the clerk to report it.
Yes, Madam Chair, there's a substitute for this bill actually, so I'm going to go ahead and get that posted right now, and then if we need to, we can read the new language if it doesn't post quickly. It should be available now. There is a bit of a lag. So if we need to, we can read the new language.
All right. Delegate Leftwich, do you want to go over the substitute and tell us what did we change to the original bill, please?
Thank you, Madam Chairman. So this bill came to me, the reason I introduced it was because of an experience I had with a client. And let me tell you what happened. There was a couple who had a child, and the father disappeared with the child. The mother was granted a protective order against the father. The child was not part of that protective order. So the mother obviously was concerned about the child and asked the Department of Social Services for assistance. They were able to locate the child. They did go into the home with the father. They found that the child was not in imminent danger from the father, and then called the mother back and said, we found your child, and it's safe right now. And of course, her next question was, well, where is the child? Because I have just as many rights to know where the child is as the father does. And he's withholding the child from me. And the department, I think, answered correctly under current law, and that is we can't tell you, we can't disclose that information to you. So this bill really is simply intended to allow the department to disclose to one parent the location of a child that may be in possession of another parent. And so that's pretty much it in a nutshell.
Thank you. Does anyone would like to move the substitute?
So moved.
Second.
Okay, the substitute has been moved by Delegate Cran and seconded by Delegate Aird. Now the substitute is before us. Delegate Leftwich, is there anything else that you would like to add? Delegate Leftwich, do you want to add anything else now that the substitute is before?
No, I think I've pretty much explained the bill and stand by for any questions by the committee.
All right.
Madam Chair?
Yes, Delegate Aird.
Delegate Leftwich, I understood the scenario in which you described. Is there, I guess I'm just trying to figure out, is this something that's unique to that one incident? I'm really trying to understand why this is necessary from a broader perspective. And is there any incidents where this could actually result in danger? Could you just go into a little bit more detail, as I'm just trying to understand whether this is a change that really needs to be made at this time?
So thank you for the question, Delegate Aird. I do a fair amount of domestic relations work, and it is not uncommon at all for one parent to take a child and not tell the other parent where the child is. I did discuss with Legislative Services, including some language that would give the Department of Social Services discretion if they believed disclosing the location would put the child's safety in jeopardy, and would be very comfortable with that language. But I see this as being a very pervasive problem, especially in a situation where you have a parent who has demonstrated hostility and violence towards another parent, but perhaps not to the child right that minute. From my practice, if we're dealing with someone who has a volatile personality and will be violent to a spouse, then it's probably just a matter of time before they're going to turn that on the next person in their proximity. And I believe it's from my client's perspective, it was important to be able to locate the father so that we could file a petition and asked the court to proceed with awarding, determining custody. Without the knowledge of that person's location, she was essentially dead in the water, trying to figure out how to get the court to intervene in the situation. So I'm surprised. Quite frankly, I was surprised that this matter had not been addressed by the law already. But the more I'm in this position, I often find that that is the case, and that's why we're here, to try to fix these problems proactively. Thank you again for the question.
Madam Chair.
Yes, Delegate Eric. And then we have a comment from council. But go right ahead, Delegate Eric.
Actually, my question is for council. And I'm sorry if I missed this, but ultimately, so does the version before us at this time allow for that discretion as referenced by Delegate Leftwich? Is that an accurate understanding?
Yes, Madam Chair, Delegate Eric. That's what I was going to point out. If you look at the very last bit of the new language in the subsection B, it does include that statement, unless the local department finds that such disclosure would compromise the safety of the child. So it does allow the local department the discretion to not make the disclosure if there are concerns about the child's safety.
One question to council from my end. Is that a regular practice though currently? Is that how we perform? That safety of the child is taken into consideration before we move into disclosing that information or not? How could it make this different? Because I believe that is what we currently do.
So this is an entirely new situation. It's not one that's currently contemplated by the code, so there's really no comparison for this. This is a case where one legal guardian has custody of the child and the other legal guardian would like to know where that child is. It's not necessarily a case where DSS has taken custody of the child and placed the child elsewhere. This is a different kind of situation. So one would think that would be part of the consideration, but because we are creating a new obligation for DSS to comply with, it clarifies the matter if you include the language in this section that specifies that the local department should not disclose if there is a concern about safety of the child.
Madam Chair, may I make a comment on that?
Sure. Mm-hmm.
So
go ahead, Delegate Left.
Thank you, Madam Chair. I agree with council, but I would add that the department is charged with making initial determinations of abuse and neglect. And so if a complaint comes in that a child is not safe, the department is empowered to march into the home and determine whether that child is potentially abused and neglected. And if they believe that it is and it rises to a certain level, they're empowered to pull the child out of the home and place it in a foster care home. So while making the analysis required by my bill is not a current obligation, it is not an obligation peculiar to the department. I mean, they're accustomed to making these findings as to whether or not a child is in danger or not. And quite frankly, that's probably at least 50% of the department's obligation is to make sure that abused and neglected children do not remain in a dangerous atmosphere.
Thank you, Delegate Leftwich. I believe Delegate Tran, do you have a question, a comment?
Yes. Thank you, Madam Chair. I was just looking up pretty quickly. I'm trying to see some statistics on, like parent or guardian abductions, and I think that they remain fairly high, even though there's been a slight decrease in the last couple of years. But they are high, and I think they are prevalent. I think the intent of this bill, Delegate Leftwich, if I may, is to make sure that all the legal guardians have kind of this same knowledge, right, in a situation like this, where you may not have custody, but you are equally concerned about the location of a child. And so I think it it allows for that. And I think hopefully that language that council spoke about gives the flexibility for the department to act in the best interest of that child while weighing the need for this type of information from both sets of guardians, one who has a child and one who's searching for that child, right? So I don't think that this situation comes up where everybody is in a relationship or a situation that it's a satisfactory relationship, right? I think something has not quite gone right in terms of how things are playing out in that family. And so I think it's where you're looking for that child. So I just wanted to make that comment.
Madam Chair.
Yes, Delegate Eric.
One final question, and at this juncture, I'm not opposed to the concept of the purpose of the legislation. I just wanted to ask a clarifying question of the patron, which is, we don't have to worry about, is it accurate that we don't have to worry about a scenario in which social services would not be notified in order to make that determination of whether or not releasing the whereabouts of the child causes any significant danger? There is actively already a process in place that would naturally involve them before that information is given out. Is that accurate?
I believe that is accurate. If a parent, they'd have no idea where the child is unless someone had called in and said, I'm concerned about the child, can you check on them? Otherwise, they would have no knowledge as to the whereabouts and have no record of it. Does that answer your question?
Kind of. I guess I'm just trying to figure out at what stage does social services get involved before the whereabouts of the child are provided to that other custodial parent?
They would not be involved at all, period. Even if someone had filed a custody petition, one parent had filed a custody petition against another parent, they would not be involved at all. The only time they're involved is when a third party calls them and says, I have a concern about the safety of this child. I'm filing a complaint about, whether they're abused and neglected. The only other time they could potentially be involved is if a parent has elected to have their support payments paid through the Department of Social Services. And in that situation, they're just a conduit to collect support and deliver it to the parent receiving support. I would not conceivably, this could come up in that context, but I think the impetus of this would all arise by one parent saying, I'm concerned about the safety and welfare of the child, and could you check on them?
So minor follow-up question, Madam Chair.
Go ahead, Delegate Eric.
So if that is the case, and we've added in this language that essentially says social services has the discretion, then from a practical standpoint, I guess I'm just trying to understand how that's triggered, especially in real time. If you have parents that are one parent calling, trying to find out, one parent actually knows. If neither of them says it's about the danger of the child, but social services has the discretion to withhold, at what point is their involvement triggered?
So their involvement would only be triggered. So I could call. I'm not in my hometown right now. I could call up social services and say, hey, I'm not sure what my wife's doing. Could you go check on the child? They'd say, why? I'd say, well, she sleeps late sometimes, and the kid may be watching television and not had breakfast yet. They'd say, that's not our responsibility. Do you think the child's in danger? Do you think that it's being abused? Are you not giving the child its insulin properly? Is it in a ketonic state? So, that it would only surface if there was an actual complaint to the department about the health, welfare, and safety of the child. And that's in order for them to do and in that situation, they would attempt to locate the child and go in and do a check and determine whether the child is safe or not. And that's the only way they would really know where the child was.
Okay, thank you.
Madam Chair.
Yes, Delegate Tran.
Can I ask a follow-up question of the patron? I had started off my earlier comment with one set of scenarios. But what if there's a scenario where you had a parent, and maybe it's not, but where there was a fear for safety from the parent who had custody of the child, and the other parent was also considered met these definitions of also being a legal guardian too. And the parent who had the child, was in a place to be safe with the child. Would the department kind of take that into consideration in determining whether or not revealing that child's location was?
Okay, so let's reverse my scenario that I gave earlier. And let's say that the mother had the child and was not telling the father where the child was, and the mother had a protective order against the father. And the father called the Department of Social Services and said, my wife is holding the child against my will, and I'm concerned against the safety and welfare of the child. And so the Department of Social Services knocks on mom's door and says, look, we've received a complaint that the child may be in danger, and we need to come in the house and determine whether or not this is true or not. Presumably, the mother would say, yes, I am withholding. You can come in, you can check on the child, but oh, by the way, I have a protective order against the father because he threatened to kill me or slap me in the face, or was walking around the house with a gun and never pointed at me, but just looked at me real mean. And so I would say that given the language of my bill, the Department of Social Services does have a discretion to say, all right, we think that the fact that the mother has a protective order against the father would potentially jeopardize the safety of the child, and we're not going to tell you where the child is. And that parent, might be at a disadvantage of getting service of process on the mother for a custody petition, but they still have remedies out there. They might be cumbersome, but there is a way to try to get this before the court.
Delegate Lefwich, I have a question also, because the part that just came to my attention, because we're going to reverse your scenario. What happens if, as a mother, I haven't called anybody yet, because we have seen cases that sometimes domestic violence or sexual abuse takes quite a bit in order for the victim to come out and press those charges. So what about if I am, it took me a while, I'm dealing with this situation, and that this actually happened in my district, by the way. I just take my, because I consider at that point that it's the safety, and it took me a while to get there. So I'm taking my child away from my husband. And right now, because I consider as a mom that that's the safe thing to do. So that's going to be a process in between 24 and 48 hours before we come out, right? Because we're going to have, once the mom is going to call Child Protective Services or is going to call the police is going to come immediately. But then an investigation is going to occur. And in that process, could it be that the judge, it's going to disclose because there are no charges right at the moment. And then we are exposing the safety of the mom and the child right at that moment, in the period of 48 hours.
Good question. A couple points I would make. The first is that the juvenile court is empowered to enter ex parte protective orders. And they can turn those around in one day. Now, there are those situations, to your question, where it takes a parent a little bit of time to build up the courage to do something like that. And what do you do in that gap of time? And again, I think that my language that we've included would give the department the discretion to determine whether or not disclosing that information to the father would place the child in jeopardy, because the mother would, when confronted by the Department of Social Services, they could explain to that person why they have not told the father where they are, and the department could take that into consideration. And I think the bill strikes a good balance between a parent with bad intentions not getting away with withholding the child from a good parent versus a bad parent using it to get access to their victim. Does that make sense?
Yes, it does make sense. All right, do we have any more questions to the patron? Now being none, do we have any speakers in support or opposition of this bill, Madam Clerk?
Madam Chair, we do not have any witnesses for or against this bill.
All right, so what is the will of this committee to move forward?
Madam Chair.
I move the adoption of this bill, please.
Second.
All right, this bill will have to be reported and referred to appropriations because there is a fiscal impact attached to it. Delegate Walker, could you restate your motion, please?
I move the passage of this bill, HB 2191.
It's the report and refer part, the passage were on the floor. Yes, so we're on the floor, then you can move the passage.
Yeah.
But right now we're going to report and refer it to appropriate. That's fine. I will, I don't want to be here, believe me. I will be watching right now. But yes, go ahead, Delegate Walker.
Okay.
So could you just report and refer to
yes, report and refer.
As amended.
As amended, yes, correct.
All right, with the substitute. Okay, and it's seconded by Delegate Air. So, all right, Clerk, open the roll. Okay, Delegate Leftwich, your bill has been reported and referred to appropriations in a vote 5-0. Thank you.
Thank you, Madam Chair.
Now we have final bill on the agenda, which will also have to be reported and referred to appropriations. And if we can bring Delegate Plum, right, Madam Clerk?
Yes, that's correct, Madam Chair. Delegate Plum is in the room. Delegate Plum, please unmute your microphone.
Madam Chair and members of the committee, can you hear me?
Yes, we can. Delegate Plum, you have the floor. Welcome.
Thank you very much. I've very much enjoyed your meeting today. I particularly commend you on that produce prescription. My gosh, that's a wonderful idea. I am here as chair of JLARC to present to you one bill that's a result of a JLARC study looking at children's services and private special education day school costs. This report was issued in November of 2020. And let me advise you that this bill is one of but several bills that would reorganize how the relationship between educational services and the special children's services in localities. What we found, and this is a study conducted by the professional staff, not by legislators, what we found and what the staff found in looking at children's services is that in fact that program is serving children who have many special needs beyond what we had sometimes understood. Now, you and the Social Services Committee understand this because you deal with the programs that deal with children with special challenges all the time. But what we found was that in establishing the special education program in the education department and the children's services essentially in local social services, there sometimes is a disconnect. And what I'm going to talk about, I don't really mean it to be critical. I mean it to be an observation of the way things came about. That being that the school systems through the IEP and so on respond to children's special education needs and prescribe programs and services. However, it is the case, and we've known this and worked on this for several decades, is that children sometimes face challenges in their lives that go well beyond what a special education school program can respond to, beyond what the IEP can prescribe. And that's when it is that localities recommends special placements in private programs and private schools. They recommend other services that might be provided in the broader local government community. And comprehensively, then, we have what we would hope would be a holistic perspective on meeting these children's needs. What we also found, however, as is the case oftentimes when you have programs that are administered at the local level, is there's not uniformity across the board. We have some programs that are highly supplemented by local governments, do an outstanding job. We have some programs that we would not necessarily call an outstanding job. Part of what the overall recommendations are related to this report is that we look at a reorganization of how children's services are provided. That's not this bill, however. What this bill does is one piece of what that new agency, if you will, or that new placement of children's services would do, would be to have the director make some assessments of programs throughout the Commonwealth, not from the perspective of simply being critical or whatever, but simply to understand what the services are that are provided and how efficient and effective they are, that we can provide the technical services and support to make those programs effective. Madam Chairman and members of the committee, as you know, we're talking about really very special children here, children who have needs well beyond what simply school programs can place. And what we'd like to do would be able to do the most effective and efficient way we can make sure that those needs are met. Now, part of the program, the study came about as a result of some people's concern that the costs escalate. And in fact, what the study found is that our costs in Virginia are pretty much comparable to what they are around the country. What happens is that we end up sometimes with kids needs beyond what we could have met in the public school program, and that we need to meet them through the Children's Services Act. Another bill, as I say, deals with this more comprehensively. This is but a small part of it, but it's a critically important part to find out how we're doing in localities so that we can then appropriate money if necessary, or we can do technical assistance and so on. Now, I have not asked for testimony, but I will tell you that Tracy Smith, I believe, is in the room, who is the lead researcher in gathering this evidence, and she can probably fill in much more detail than I've offered you. But that's the overall thrust of this, to be able to make sure that we can gather the information necessary to know how we're doing and to make sure that children throughout the Commonwealth, regardless of their zip code, get appropriate services.
Thank you, Delegate Plum, for your thorough explanation. Thank you so much. We appreciate it. Madam Clerk, do we have Tracy that would like to say a few words, or anyone in support or against this bill?
So, Madam Chair, we do not have anyone to testify, but we do have Scott Reiner with the Office of Children's Services to answer questions, and Tracy Smith with JLARC to answer any questions that the committee might have.
Okay, Scott, welcome.
Thank you, Madam Chair. Good afternoon, everyone. I'm here really to respond to any questions that you might have. The administration has no position on this bill, but the Office of Children's Services is prepared to implement it should it pass. There is a fiscal impact attached to it, as we would require some additional, one additional staff is projected to be needed to do this, because you may or may not know we have a very small office here responsible for monitoring and implementing the act across the state. But should the resources be provided to us, we stand ready to implement the bill.
All right. Do we have any questions for Scott from members of the committee or to the patron? All right. Thank you, Scott. I don't think we do. This committee works by motions.
Move to report.
Second.
Okay, the bill will have to be reported and referred to appropriations.
I amend my motion to move to report and refer to the appropriations committee.
All right. So,
Madam Chair?
yes, Delegate Aboli.
I would like, if possible, to make a comment in support of the bill itself.
Sure, go ahead. I'm sorry if I oversee that you wanted or saw they wanted to participate. Go ahead.
This is for Delegate Plum. I appreciate you bringing this forward, Delegate Plum. As some of you know, I always call myself a recovering high school principal. And what I've found many, many times that the left hand does not talk to the right hand. And the kid in the middle is the one that always gets the brunt of it. So hopefully this will bring all the parties involved to talk to each other to provide the service for the child. Thank you, Delegate Plum. Thank you, Madam Chair.
Thank you, Delegate Aboli. So we have a motion on the floor to be reported and referred to appropriations. And can we open the rolls, Madam Clerk? Okay, Delegate Plum, the bill reports 5-0 and is reported and referred to appropriations. Thank you so much.
Thank you, Madam Chairman and committee. Thank you.
Thank you. A question to Council. I was looking at House Bill 2191 that we just passed to report and refer to appropriation, and I was reading the fiscal impact and it says 0. So do we need to? I don't think so, right?
It may not, and we'll clarify before we get to the full committee meeting so that we will have the appropriate motion at that time, for sure.
All right, sounds good. So with that, we have completed our agenda, and I want to thank each one of you. And if I could have a motion to adjourn.
So moved.
Okay, thank you. We'll see you next week. We still have we still have a few bills coming up next week. So look forward to seeing you next Wednesday at 11. Thank you.